Breaking news this hour, we are awaiting former President Donald Trump. He's expected to speak at any minute. And you see, this is Mar-a-Lago on the bottom of your screen. That's where we expect to see the former president. And obviously, that's the U.S. Supreme Court in the top box to the right there. The Supreme Court's huge, unanimous decision today reversed Colorado's decision to ban Donald Trump from its primary ballot. All 9 justices ruled in favor of Trump in this case, which will impact the status of efforts in several other states to remove Trump from their respective ballots. For instance, we know in Illinois and Maine, they were already planning to do that too. So all of this ahead of Super Tuesday, which is tomorrow. This ruling is huge, and we've already heard from his camp, it's a big win for America. This is Outnumbered. I'm Harris Faulkner, here with you today. My co-host, Kayleigh McEnany, and Emily Compagno, also television host and author Kim Douglas, and Fox & Friends' first co-host, Todd Pyro. All right, Todd, I'm going to start with you. Just first of all, the legalities of this, spell them out, and how much of a victory is this for Trump?
It is a tremendous victory. And in our coverage starting at 10 o'clock this morning, one point was made over and over. This is not just a decision that applies to Colorado. This does apply to all the other states that are going to try this. Whether it was Turley, whether it was McCarthy, or whether it was Shannon Breed, that point was made over and over again. But why the underlying decision is so important for our country? Instinctually, everybody on this couch knew that what Colorado was trying to do was fundamentally wrong from a democracy perspective. We cannot have some random state bureaucrat decide because they have an animus against Donald Trump that the rest of the country cannot put him in office as president if they so choose. And the 9-0 decision made that abundantly clear. Those justices, the liberal ones, certainly don't like Donald Trump, but the decision here had to be 9-0 for the sake of, wait for it, Harris, democracy.
Well, and, you know, Emily, one thing that Jonathan Turley and Andrew Trzaskowski, who was also with me last hour, we were all talking about is that we are one voice coming from the U.S. Supreme Court. And we are not all one voice in the United States of America right now. We're divided. They showed us what unity looks like around a purpose and a mission.
Yeah, you know what I love about this opinion, which I have in my hand right here, is how clear it is.
Yeah.
Anyone can read this opinion and understand exactly the logic behind the Supreme Court's unanimous ruling. And to your point, what we all expected, because this is exactly what the Constitution stands for. And what I love the most as well, their opening line as they come out, because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3 against federal office holders and candidates, we reverse. And they go on to explain that the 14th Amendment expanded federal power at the expense of state autonomy. So this entire decision is essentially saying, look, at the end of the day, you are trying to apply something in Section 3 within the 14th Amendment to give states a little bit more power. But nay, that is from Congress. And ultimately, they say, because of the people. And we talked about a lot that the fear, the tragedy that might happen if they ruled in a different way, and it was the patchwork application. Remember, it was the fact that why can Colorado have an impact on what people in South Carolina decide? That the reason or the reasoning is absolutely not they can't, that at the end of the day, the patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. Nothing in the Constitution, they say, requires that we endure such chaos, arriving at any time or different times, up to and perhaps beyond the inauguration.
Well, we've seen a lot of chaos. And part of the problem has been people have, you know, continued to lose trust in government agencies and elections on that list too. So, and I don't know, I'm going to ask the team, do we have that map that showed the patchwork that Emily mentioned? We had it late last week. I mean, it really showed how divided the country would be all over the place. Like maybe one state, Trump's name would be on the ballot. The other state, no, this state is fighting to get his name off that. I mean, it would not have been a helpful situation for voters. And I think, you know, Kayleigh, we want to make it as easy as possible for people to express their voices because the time is critical. That's an even better look at it. All the states with lawsuits to bar Trump from the ballot, and it's all over the place. The pending are in yellow.
So I'm so glad you brought up this map. When you go to page 9 of this opinion, footnote 3, there is a jarring statement in the opinion. We are aware of just one example of state enforcement against a would-be federal officer, and it was in, get this, 1868. The reason I bring that up, so this has been used once in 1868, but you just showed that map of states, the patchwork. Where is the brazenness of these judges, of these Secretary of States who think we can do things that have been done once in United States history? And not just brazenness. You look at Colorado, where they said you can't even write in the candidate. You look at Maine, it was one unelected Secretary of State. And then you move over to Illinois, and they actually use the word suppress. I just want to quote them exactly. The Illinois State Board of Elections shall remove Donald J. Trump from the ballot or cause any votes cast for him to be suppressed. That is the word they use, the brazenness.
I thought Democrats were fighting against suppression.
Right.
I'm so confused. They need to make what rules they like on certain days clear, because we can't keep up.
So thankful for Ketanji Brown Jackson, for Elena Kagan, for these justices appointed by Democrats, Sotomayor, who said the rule of law matters, democracy matters. This is Americans' institutions working.
Kim, I saw you nodding when Kayleigh hit the point of taking his name off the ballot, and you couldn't even write it in.
No, not even write it in. I love what you said. I thought they were supposed to be saving democracy. We need to know from day to day. But it's so true, and I've been reading a lot and going on TikTok for social media, getting the update, and they're like, you know what, it was bad behavior, so we need to get him off the ballot. I want each one of you to promise me right now you will not talk about my behavior behind the scenes. Because if we went on bad behavior to wipe people off of their jobs, I mean, I'd be working nowhere.
Yeah, you know what? When you put it that way, I want to bring in now Shannon Bream, chief legal correspondent, Fox News Sunday anchor. So, Shannon, I don't know if you could hear the conversation, but when you put it the way that Kim Douglas just, I mean, it was almost like Colorado, Maine, Illinois, and some pending states want to cancel Donald Trump. They got all caught up, kind of woozy on the cancel culture.
I do think that there are some state officials out there who would be very happy to keep him off their ballots. They're not going to be able to do that now. But I would note also during the arguments, Chief Justice Roberts brought up the fact that, okay, if we say it's all right in this instance, that doesn't mean there won't be states that will say, okay, let's get some Democrats off the ballot then.
There you go.
And then what happens if you have a patchwork of states saying no Democrat candidate on our ballots, a patchwork of states saying no Republican ballot? Then what? Then you have a handful of states that have both the D and the R, and those are the only people who get to decide who is the next president of the United States.
Right.
I mean, in the opinion today, they talked about that as well. And this patchwork idea that Emily brought up, they said essentially that if you allowed states to do this, it would go against this idea, the principle that our country is based on, that the president represents all the voters of this country. And if you have only 20 or 30 states making that decision, it's very hard to say that's actually where we've gotten. So the justices spoke with this one voice. Again, there were the four justices who had their own explanation they wanted to offer. Justices Sotomayor, Jackson, and Kagan feeling that the broader opinion went too far and got into questions they didn't think needed to be decided. But I thought it was interesting that Justice Barrett kind of brings the whole thing together and said this: for our present purposes, our differences are far less important than our unanimity in this decision. All 9 justices agree on the outcome of this case, and that is the message Americans should take home.
I mean, that's amazing that they would actually make this point in their comments. I mean, that's how critical a juncture that we're at in this country. Like, yes, we are divided on things, and thank goodness that we are. We would be so boring if we were all the same. We get together, we're a great country, but we have to be able to do it with civility. So, you know, Shannon, as you were talking, I was thinking, what are voters in those states now who suddenly know today, ahead of Super Tuesday, that this is in some way settled? Now, look, those states can do what they want. They can still try to fight the good fight, but I'm pretty clear what 9-0 says in the U.S. Supreme Court. So now I'm wondering, you talk about excitement and intensity in the recent polling, and I know you've looked at this because I think you had it on Fox News Sunday just yesterday. When you look at the intensity among Democrats versus Republicans, imagine the intensity in these states that, particularly in Colorado, where people who wanted to vote for Trump can now say, and my vote will count.
Exactly, because these secretaries of state, these different officials in the different states said, we're going to let these names be on the ballot. Our decision is it shouldn't be there. And as Kayleigh pointed out, there was language that said, if, President Trump loses this thing, we're not going to count these votes, whether they're write-ins, whether his name's on the ballot. But they put them on the ballots because they knew they were waiting this decision from the Supreme Court. So one of the briefs in the case talked about that and said, how are we supposed to ask people to go to these polls and to vote for President Trump with no guarantee that their vote's actually going to count or matter? You can't take that away from the voters. So everyone who goes out for Super Tuesday tomorrow in Colorado and Maine, who was at some doubt about whether their vote would count, it is going to count tomorrow. If you decide and choose to vote for the former president, Donald Trump, it's going to count.
All right. I just want to bring everybody's attention to the box on the left screen. We saw a little camera movement there, so I don't want to lose sight of what we're doing. And that is we are awaiting the arrival at this point of Mar-a-Lago of the former president, Donald Trump, to speak on the U.S. Supreme Court victory that he and his team, I'm sure, are cheering behind the scenes. I mean, they call it, an avalanche type of decision here between this and Super Tuesday, which they expect to lock in a nomination. So they're all shades of optimistic at this point. We expect to see the nation's 45th president momentarily. Kayleigh.
It's significant to me, Shannon, that you had Kagan, Sotomayor, and Jackson joining with the majority here in a 9-0 unanimous opinion. But Kagan opens the concurrence this way. It is not necessary to decide more to dispose of a case than it is necessary not to decide more. So she basically is saying that the majority opinion, the per curiam decision, went too far in saying the role of Congress in this decision making. What in practicality does her concurrence mean? Does it look more like a 5-4 decision?
Well, some would argue that, but I think, again, what Justice Barrett makes clear is we're 9-0 on the question before us, which is whether or not Congress could do this or whether it's left to Colorado. Colorado clearly cannot do that. All 9 agree that that decision is reversed. It is no good. States can't do this. But there was an in-depth discussion in that per curiam, or what you would consider the majority opinion in this case, that does talk about the history, the congressional intent, and all of those things that those 3 justices who got together on that concurrence, what are considered the liberal justices on the court, didn't want the court to get into that. In fact, in one part of their concurrence, they say essentially they've cleared away questions for a future potential insurrectionist, that those questions wouldn't have to be answered in those future cases, which I think a lot of people would say, listen, I don't think the Supreme Court is clearing the way for somebody who's a convicted insurrectionist to have no recourse against them when it comes to the ballot. But what they're saying in this case is that's left to Congress. The states can't do it. Those 3 concurrence opinions from the liberal justices were essentially, we don't want all those questions answered. We think the court went too far, but we do agree with the 9-0 bottom line.
Emily, before we go to you, I just want to let everybody know as the president comes up, the former president, we will go to that right away.
Absolutely. And Shannon, just to sort of expound on what you're saying, that's why at the end, mentioning the concurrent comments, the main decision says, look, these are not the only reasons that the states lack power to enforce this particular constitutional provision with respect to federal offices, but they're important ones. So yes, it's important to note, but it's not the only reason. So I think that dispels clearly the notion that, well, there is room up for interpretation, or perhaps there could be wiggle room later for states. I found it fascinating as well in this, as we dig into the bones, Shannon, how the Supreme Court noted that not only is there precedence for, of course, federal authority over the states here, but there's 0 precedence for the states to utilize to apply this section in this way. And I found it notable that the Supreme Court said, look, if we allow this to happen, in part, it could be a preponderance of the evidence in Maine and, a substantial amount of evidence in California. There's absolutely no uniformity. And that's what voters and Americans deserve. And something so sacred federally is the uniformity that we can count on. And what do you make of the political tone as well that, that this administration can sort of wield a bloat of the federal government as to when they want that, and yet the Supreme Court strikes that down, and at other times states can try to rise up and the Supreme Court will knock them down. There's a definite delineation happening with the Supreme Court under this administration in particular that I think shines in favor of the American voters' autonomy.
Yeah, and I think that that is what this court is all about. They want to be apolitical. They want to settle these questions. Of course, there are going to be fights between the feds and the states. The other big one that I think comes to mind right now is the issue over immigration. You got a number of state battles and state laws out there. Remember covering SB 1070 out of Arizona years ago at the High Court, where there's this fight between which powers for the feds, which powers for the states. They may get to that with this law that's being challenged in Texas as well. But in going through all of those things, they did look at the historical record. And Emily, as you mentioned, where are the examples of this in the past? And during arguments back on February 8th over this, that's one of the questions that the attorneys got. And I think, if I remember correctly, it came from Justice Thomas, who said, where are the extemporaneous examples of when this was passed, it being used in the way that you are arguing it should be used now to allow a state to keep a federal candidate off a federal ballot? And the attorney couldn't answer that question. That was a big moment in the case back on the 8th.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kaylee McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.